This is lecture 3, 288, legal process. We're going to finish up the part on advocacy, and then we're going to move to complaint. Hopefully get through that, and then move on to opinion and answer. All right, so we want to always look at, I might have ended with this last time, but favorable case law. To advocate, you have to really have a few things in place, and not the least of which is understand the favorable case law that's going to support your argument. In-depth analysis of adverse case law. You can't just get case law that supports your argument. You have to be prepared to deal with the arguments made on the other side. Not necessarily do you have to address them, but you have to be prepared for them. Let the other side make their own arguments. And then you have to synthesize all of this to come up with, an argument based on the facts that are presented that is a winning argument. All right. We're on page 361 here. If anyone wants to know, there's an example here. Counsel for Betty placed her affirmative arguments and positions of priority before distinguishing or discrediting authority supporting counter-arguments. All right, so you have to make a decision. You'll see with everything that what the approach is going to be and the order in which you're going to approach things. Some things are already preset in terms of what the court's accustomed to seeing. And so as a consequence of that, not there's less leeway, but you have to be careful that if you are deviating from any process, that even though there's room for you to do that, that's serving your argument or supporting your argument and making it stronger in some way. So you can go through you set things up in that first paragraph, the second paragraph, third paragraph, where you're synthesizing case law. Again, you have to keep in mind, facts, right? Those facts formulate some sort of legal approach in terms of a statute or what have you. And then once you have that, you have to think about how you can approach and putting together a winning argument, which means looking at other cases like yours that have gone before yours, and the court has made some sort of decision on. So remember, you're always going to start with favorable case law. So paragraph by paragraph, inductive reasoning, right, laid out. You have to assemble this thing step by step. So I'm going to read. Give you an example of all of these. There's several paragraphs, so I want you to be able to sort of piece this together and get a sense of it. First, the in-depth analysis of favorable case law, page 361. All right. The Federal Food Quality Act, FQA, preempts more stringent state legislation seeking to ensure the quality and purity of food produced or sold in interstate commerce. Okay. Right away, they're talking about the act, or the statute that they're, going to be using, and they're saying that preempts, the state legislative, statute or what have you. They give a case, State versus Biggs, right? And they give they cite it, and then they use it. In Biggs, state officials sought to enjoin the marketing and sale of fruits and vegetables advertised as organic, quote unquote. The officials invoked a Calzona statute that set criteria for food label or advertised to be organic, right? They cite another case. Sorry. The Calzona Supreme Court held that the FQA, so we're going back to the Federal Food Quality Act, provisions regarding organic produce were intended to be exclusive and to eliminate unreasonable restrictions on commerce. That was their purpose. Why is that important? Because if something is written, a statute would have you, and it has a purpose, it's to address a policy issue. And so you have to be guided by that. The idea of writing it in the first place was to deal with, address, and effectively either resolve or what have you, a particular problem. So whenever you're going to cite a case, or you're going to cite a statute rather, you have to think in terms of what the purpose of that statute is. And that's going to be sort of gleaned from debates in the legislative body, whether it's state or federal, and of course refined as it's been applied in case law over time. All right, The Arizona Supreme Court held that the FQA's provisions regarding organic produce were intended to be exclusive and to eliminate unreasonable restrictions on commerce. Okay, it therefore held that the FQA barred the state from prohibiting such regulation. Okay, we're dealing with a case here of, on the federal level, whenever there's interstate commerce, and that's become very, very sort of vague in terms of what qualifies interstate commerce and what does not. Basically, everything nowadays is under the control of the federal government. Nevertheless, it goes on. In reaching this decision, the California Supreme Court exhaustively analyzed the legislative history of the FQA. Okay, it noted, and it goes on from there. So they looked at the history of it. Why? Because that history, right, determines its intent, right? Why was this thing written? How has it been applied? What was its goal? Does it apply in this case? If it does apply in this case, then you must make an argument that's consistent with the purpose or the goals of the policy itself. You have to say, given these facts, looking at the purpose of this policy, as is manifested in the statute, when you look at that, you look at the facts here, you can see that we have to apply the statute in this way to these facts that then bring about a certain result. Okay, so let's look at the depth of analysis. This is important because you're presenting arguments. Okay, you don't want to present any more, either in written form or in court, that is absolutely necessary to accomplish your goal. Now, I know that sounds like you want to really pare things down. Not necessarily so. There are times when you want to go ahead and you want to actually maybe make a more expansive exploration or go into more facts. The problem there is every time you expand the analysis, you give a gateway into the other side and for the court as well to move around, and you open up some doors. Sometimes you need to open those doors to make your argument. Sometimes it's a complicated issue and you have no choice but to do the analysis in such a way that's a lot broader because you have to break down the elements, because those elements actually impact your case in various means. So keep in mind, be careful. You have to exercise control over the depth of analysis, how far you go into things. Okay, some people, it's not a dissertation and it's not a lecture. It's a presentation of your case and the facts that are relevant and your analysis to those facts given the particular statute or what have you. So we look at this, and there's three different levels of depths of analysis. The first is light analysis. And here the goal is just to present the fundamental and undisputed propositions with direct statements of law and citation to authority. So light analysis, it sounds, I don't like that's how we express it, but I don't like the term light analysis. It gives a sense that this analysis is not very good, or that it's just an overview, it's just a brief. But that's not the case at all. It's the most pared down type of analysis. That is, you're only bringing in those things, right, that are necessary, right? They're fundamental, and they're undisputed. It's well accepted. Propositions, direct statements of law, and citation to authorities. That's it. Here's a statute. This is what it is. Here's the authorities, and we're done. All right. The in-depth analysis, the second sort of level, what have you, of statutes of case law to explore the policy and reasoning. Now, okay, so first is almost like, here we go. Here's the fundamental and undisputed propositions. These are direct statements of law and citation to authorities. You're setting the groundwork. These are the statutes, case law, what have you, that we are relying on. This is what we're focusing on. This is what is at the foundation of the case, right? When you start going into the in-depth analysis of statutes or case law, now you're exploring the policy and reasoning, right? Statutes, all right? So first, you're fundamentally saying, here it is. This is what we're looking at. Now, we're going to take the second step. We're going to go in greater depth into the analysis. What's the analysis going to be? Of the statutes and the case law All right, and why are you doing that? The statute itself has got to be interpreted. The case law gives interpretations, and what you're looking to do is explore the policy and the reasoning. There's a great book I might have mentioned before called, Getting to Maybe. What it is ultimately it's about policy. All statutes, and I've said this, and you've got to keep this in mind, all statutes, all common law are designed to address a fundamental issue, right? We have legislative bodies to do that. Here's a new issue. Here's a problem. How do we deal with it? How do we approach it? And one of the ways is to write new law and create new policy. Here's the policy for dealing with that issue. Okay, and then of course we argue over what it all means. But this, the analysis of the statutes and the case law is really about exploring the policy itself, what it does, what it means, how it's constructed, and then looking at the reasoning behind that policy. How did they get there? What were they hoping or intending to do? Right? So advocacy really requires you, if you're going to advocate for a side, to know exactly the foundational legal sort of premises upon which you're going to build. That's that first part, the analysis of the fundamental and undisputed propositions, right? And then the second part is, okay, everyone accepts this, yes? Now let's talk about the purpose behind the statute, the case law, and let's explore the policy and the reasoning for it. You're going to have to tie the reasoning and the policy, goal or goals, and that has to be established through looking at the statute itself, the words, that how it was debated in the legislative body, and so on. You're going to have to look at that and try and make your argument. Remember, if there was no possible way to ever interpret, misinterpret, or expansively interpret some statute or some debate in the legislative body, there'd be no need for the courts. If you think about it, if the law were black and white, if the law was very clear, covered every situation, you had to read it, you said, this is a violation of it, and that's all. It doesn't work that way. Here you go. Again, a lawyer's stock and trade are words. Understanding them, what do they mean? What was the purpose of them? All of this stuff, this approach is important. So when we get to the in-depth analysis, now we're making our argument, and now to go back, you have to be careful about how much you include in that argument. What is necessary? What is essential? What might be secondary or tertiary to making the argument? And you've got to be careful. That's a slippery slope. Pretty soon you're bringing in an awful lot of stuff, and for lack of a better way of expressing it, you're confusing the court, let alone the jury. The court wants to know, what's your argument here? Give me your position. Support your position, right? How do you support it? Statute exploration, case exploration, so on and so forth. So that's the meat of it. Up top, that light sort of introductory analysis is here you go. But this is critical because if you cite wrong here and you're going down the wrong path already, you're going to have some problems. You shouldn't make that mistake. You got to at least know the fundamental undisputed propositions that exist, right? And so you quote the right authorities and all of that, right? So on the federal level, it's on the state level, whatever. Then the in-depth analysis is really where your arguments are making. You're trying to take your facts, come up with a rule based on the statute's interpretation, its goal, and all of that. What's the rule here? What is the purpose? Think of rule as purpose. It's helpful. It's not completely accurate, but it's helpful. You want to then show through, you want to do what we call a rule proof. You want to use cases and background information, everything you can to say this is what this rule means. Up top in light analysis, you've laid out the fundamentals, and now you've got to explore the rule that should be applied here. And the way you do that is by looking at the case law itself and looking at the legislative, analysis. They hold hearings, they debate issues, right? They discuss what the purpose is. That's what you want. If you're going to say something applies here, you better be able to support it. Not just because you believe it applies. You've got to demonstrate there's a rationale behind it, a reasonable interpretation of the statute itself based upon the legislative body's debates and so on, and also the way in which this has been applied in previous cases. that this is the rule. This is what they meant by it. This was their purpose in the policy. So we can take our facts in this case based on these the fundamental and undisputed propositions, then go prove out what that rule is that we're going to rely on by looking at what the rule is supposed to mean, what the effect of the rule is supposed to be, why it was there as a policy resolution of some sort, and you come up with you prove out that rule proof, right? That's the rule here. Now you've got to take that third step, and you've got to be able to take the rule that you now say exists and you've proven it exists and here's how it's defined, here's how it's used. You've now got to take that and somehow apply it, right, to your case. You've got to take that rule and you've got to apply it, a rule application, right? You've got to apply it to say, see, this applies here, and this case should then be decided as all previous cases because they belong in this family of cases or under this particular statute. Then finally, there's direct statements of law and citation to authority with parenthetic explanations for an intermediate level of analysis. Okay. All we're talking about here is now you're getting down to it. Now you're making your argument. You're tying those facts and the like. So you can think of that second part. First is just an introduction. These things are fundamental, and this is what we're building on. Then the in-depth analysis is okay. Now we're going to rule proof. We're going to go ahead and look at the rationale behind everything. I'm not being exactly on point here, but at this level, this is what we want to get out of this. Okay, and then the direct statements of law and citation to authority are going to then help you go ahead and get to that other level of analysis, and hopefully be able to accomplish convincing the court or the jury that your particular interpretation, given the facts in your case, your particular interpretation of how those facts get applied is a winning argument. You have to know what the other side's doing. You have to know what the weaknesses are, right? Go back for a second. Some law firm is deciding whether to take something on, so there's a memorandum of law written, by someone at the law firm, a junior partner, what have you. And their thing is to lay out, hey, are we going to win this case? Well, tell me what we got going for us. What arguments are we likely to win because we can support them, and tell me what we can support them with. What arguments are going to be presented that we're probably going to lose or not win? And when you take those things at sum, what's the likelihood of winning this case? Now, when you submit that, we've talked about this, most of those that are going to read that, partners or what have you, they want to know up top, how does this story end? We're likely, to lose the case. Okay, that's all right. Now I know we're going to end up. Now let me see why we're going to lose the case, because maybe we're not. Maybe there's something we haven't thought of here. That's a strong argument on our side, but they have this argument. How can we counter that argument? How can we reshape that rule, or at least present the rule in a different light? So here you have to understand that if you're going to advocate now, you're going to go to court. Keep in mind that could be the end. That could be the end goal, or that could be where this is going to end up. You're going to have your ducks in a row. You're going to have done this analysis. You can't go in and not know the relevant law, the relevant cases, interpretations, and all of that. Now, it doesn't mean you can't make interpretations that have not been made before. You can always, and there's plenty of instances where the court has interpreted something in one way and then over time has interpreted it in another. In other words, sort of fundamentally accepted ideas are no longer relevant. So you have to build on new ideas because the law has to adjust over time, right? No law as written, there's not a single statute that can stand on its own without interpretation and without reinterpretation and further reinterpretation, because one thing that's constant is change. Socially and the like, new things crop up, technologies and things we didn't even think about before. And so we constantly reassess. Even constitutionally, everyone sort of looks at the First Amendment and goes, well, we know what that means. No, we don't. We have a fundamental idea of what it means. We know how it's been applied in the past. We know where they've changed the application in the past. We know now there's new technology. Should that be included and protected under freedom of speech? It gets very complicated, and that's the both the joy, I think, and the mountain you have to climb when dealing with the law. So now a good brief, right, to the court should employ that full range of analysis, right? You do that effectively. If that brief has that, now again, you don't want it to be any more voluminous than you have to have it. And the more there is, because there's more particular aspects in the case, you're going to have to really organize that. That's the thing. The court has to read it, and the jury has to understand it. So you've got to be very adept in making your argument clear, succinct, bringing in only those things that are necessary to advance your case towards your goal, which is obviously to win. All right, so a good brief then is going to have all of that. So, all right, keep in mind that we don't want to jump into something very complex here. That would be, I think, very difficult. All right, the fourth thing, the next thing, is presenting your authority. You have to lead your reader through each of your arguments and support your assertions of law with supporting authority. Okay, you're going to say X. How can you say X? What authority, right? What authority does X rest upon? In other words, you can't just you've done some reasoning here and you think it should be. You're going to have to show either something that definitively says, in this instance, that this is probably the way the court should look at it and make your best argument. That's critical, right? You've got to be able to do that. If you can't do that, if you can't cite authorities and say, okay, these cases and this is how the statute was developed, then where do you start from? And the law, right, stare decisis, we want to keep things consistent. That's important because if the law is not consistent, how do we all know how to act? Right? If we don't know what the law means, then how can we adhere to it? It's very important. Lawyers are supposed to know and keep abreast of these changes in law. The authorities that may enforce those laws need to understand what those laws mean and why you enforce them, and therefore how you enforce them. So you need consistency. Courts can't just go around making decisions without basing it in those things which came before. And where those things that came before no longer can be applied, the court has to take a new direction, and those making the argument before the court have to lead the court there. Here's all the support, cases and so on, but we can see this doesn't fit in it. But the intent of the policy was to do X. And therefore, if that's the case, we have to adjust things. We're not going to get case law that supports this directly. We're not going to get analysis of a statute, the statute itself that may support this. But if we look at the intent and the purpose behind it, it would have to include this. Then again about First Amendment. All right, so you've written an email. What rights do you have to express yourself in that way? When telephones came along, cell phones, the question was, well, if you get a court order, a warrant to tap a phone, but there's no wires. So how do you do that? Should you be able to do it? And under what circumstances? Now we have to reorganize our thinking, but we have to think in terms of, okay, before, when there were telephone lines, landlines only, the court decided that, look, if you're tapping the phone inside the home or inside the business, that's one thing. But once it leaves that physical plant or home, can you tap into it there? What about cell phones now? There's no lines. So what's the idea behind giving a warrant to tap a phone? That's what we have to apply here. The goal is to do X. So we've come up with basically is that you can listen to these conversations, but you can't en masse, let's say. You can't bring people in that are not relevant. You have to protect their rights, their privacy rights. But the freedom to express yourself is now being limited, right? You can't depend upon, an extensive, right there. Okay, so that's what we're really talking about here. So again, now presenting your authority, again, you have to synthesize those authorities. That's the first thing. Or other thesis statements into a topic sentence or paragraphs. It has to be structured. You have to remember that someone, either a panel of judges or a judge, is reading this. And you have to have your arguments lined up and clear. It's best to repeat for each particular authority or what have you, every argument you're making, repeat things in the same order. Synthesize those authorities or other thesis statements into a nice, neat topic sentence or a paragraph. So I know what we're going to be talking about. I know what I'm going to be reading, right? You can't get to that in the third paragraph, right up top, right? What you're going to demonstrate and how you're going to do that. Now, it could be just one sentence or it could be a paragraph or paragraphs. Remember, the more you write, the clearer you have to be. You always have to be clear. But as you walk into the tall grass here with more verbiage, you have to be very careful that your arguments that you're developing aren't kind of lost, right? It has to be well thought out and well organized. So the second thing here, besides the synthesis of the authorities, unless you've got citations and the like for those authorities that are independently significant, they don't need anything else to bolster them. Then you take your ideas and you relegate those citations to supporting citations, sentences, and so on. In other words, you start from the top, your most powerful argument, and a particular, in this case here, citation, which is you're citing something that you're going to build an argument on, and you want to be very clear about that. I would argue that the first three steps here, and those analysis steps, are critical, because if you can't do that effectively, I don't know how you write an effective brief or the like, or a presentation to the court. And then finally, you're going to have to look at substantive overviews, and you're going to ask the judges to adopt your interpretation of the material that you've explored. Take the authorities, bring them together. Second step, look for those independently significant and focus your attention on those citations, and then introduce quotations from those citations that could then again substantiate your views, and hopefully your interpretation will be adopted or accepted by the court. That's how the process works. Now, we've left out something very important. The wellspring or the foundational approaches we've talked about have to apply to the facts at hand. So, if you go to law school, for example, fact patterns. What are the facts here? Because the facts will drive your entire analysis, and also what area of the law you think you need to be focusing on in order to create those winning arguments. So, for example, criminal law is different than tort law, right? Civil wrongs. There's a different approach, right? We have those standards beyond a reasonable doubt, right? Preponderance of the evidence. If you're going to be putting someone in jail or taking their life, you want beyond a reasonable doubt. In other cases, it's just a preponderance of the evidence. Why just a preponderance? Because you can't have all the evidence you need. You're not going to have 100%, every little piece. Even some sort of video or the like taken during an event is not going to necessarily be enough. It's open to interpretation. Was it edited, and so on and so forth. So the facts are critical. The facts are going to direct you, right? The facts are going to direct you. So someone's walking down the street. There's construction work going on. They trip over something that dropped off of, say a building that they were working on, even though they had, erected all kinds of scaffolding to protect the sidewalk. Someone trips over that, right? That's one type of case, if you will. it's a wrong. That person should not, or that company should have not left that there on the ground where someone might trip over it. Take the same facts, someone tripped over that particular, but change the important and crucial fact. Somebody that picked that up and threw it at someone, they were in an argument. That's different now. Now, do you want to go after the company that left it there, or do you want to go after the person's criminal act that assaulted this other person? What do you want to do? Same material was there, the scaffolding, the brick, or whatever I said it was, but now the intent has changed and everything else. So now it's a different type of case, right? Okay. The analysis of the facts then, the opening statement in an appellate brief, because you're appealing now, is most effective if it does not prematurely argue the law or the application of the law to the facts. I'm reading from 363, right? In contrast, when you analyze the relevant facts in the argument section of a brief, you should explicitly reach a conclusion by relating the facts to the previously discussed legal rules, right? The legal rules have been established, right? Rule proof. You may accomplish this by 1, directly applying the law to the facts, or 2, using a form of inductive reasoning to analogize and distinguish precedent by comparing the facts and reasoning of the precedents to your own case. Okay, so what does that all mean? It means you could take the actual rules and you can take your facts and apply them to that rule, or you can say, I have to now, through some inductive reasoning, give an analogy that will apply that rule to my case, the particulars of my case. So there's a couple of examples which I think are worth looking at on 363. To illustrate the first technique, suppose that you have established in your decision of the law that a state police officer can be liable for punitive damages. Those are damages that go beyond your actual damages. They're damages that are there to punish you, punitive in nature, because the court thinks that you might repeat this behavior. So they're going to give you additional damages you have to pay out or what have you, to prevent that kind of behavior from happening again in the future. For recklessly depriving a citizen of her right to be free from arrest without probable cause. Okay, so it's about probable cause here. In the fact analysis of your argument, you could directly apply that the rule of law to the facts by showing how the defendant, police officer, acted recklessly. That's a key thing. Okay, so here it is in the actual transcript here of some testimony. Okay, substantial evidence in the record supports the jury's finding that Officer Mullins acted with at least reckless disregard for Wong's clearly established Fourth Amendment rights. Mullins' actions show that even he did not believe that Wong fit the dispatcher's description of the robbery suspect. According to his own testimony, when he initially spotted Wong moments after receiving the robbery report, he passed by her and continued looking for the suspect. Only after failing to find a suspect who fit the dispatcher's description did he relocate Wong and summarily arrest her. The jury could infer from these facts that Officer Mullins felt compelled to arrest somebody for the robbery, and that he recklessly gambled that Wong might have been involved simply because of her general proximity to the robbery. This is precisely the kind of reckless disregard for constitutional rights that an award of punitive damages is designed to deter. Probable cause has to be, you have to have that. That doesn't exist here, right? So it's just the person happened to be around the area. So did a lot of other people. All right, so you should read what's on 364 too in terms of analyzing or giving an analogy favoring the case law and the facts. That'll help, kind of bring things together. And then finally, you end up with a conclusion that you're going to come to, right? So immediately after your fact analysis in each argument of your brief, each argument, you're going to give a conclusion of that argument. You see, so when I'm done with that argument, I have all the things necessary to evaluate that argument, right? Those different depths of analysis, the different ways in which we're going to rule proof and apply it, and then what our argument's going to be. And now we get to a conclusion. Immediately after your fact analysis in each argument of your brief, you should briefly repeat the conclusion that you previewed in a point heading for the section or subsection. Now you're saying, see, this is what we're doing. This is how it applies. So a substantive conclusion need not take up much space. If your arguments are simple, your conclusion need only briefly generally repeat the request for relief and the supporting grounds, as is the closing to a brief in support of the motion to exclude evidence before trial or what have you. In other words, if it's simple and straightforward and you've really demonstrated, very brief statement at the end. Okay? In more complex cases, right, the conclusion might briefly summarize multiple arguments. Again, the more you expand the arguments, the more specifics there are, and the various different arguments makes it absolutely necessary. It's always necessary, but I mean absolutely necessary here to be able to bring together those facts in a way and apply them, the rule to those facts in a way that a court can understand, a jury can understand it, right? Think of it this way. If you say to someone, I'm going to prove that I didn't do this, and I'm going to discuss 3 facts, and I'm going to put those in the light of the rule that determines whether or not there's been a violation. So fact 1, you go through the whole thing, depths of analysis and all of it, and you get to a conclusion and you demonstrate that that wasn't present. You do the same thing for the second fact or groups of facts, and for the third, and you demonstrate that those things weren't present in this particular case, given the facts, given the rule, given the nature of it, the statute, why it was written, and so on. And then you present that to the court. There are 3 things here. We've done an analysis of each. We've tied them to case law and to the meaning of the statute. And the facts here don't fit. The facts here don't fit. And therefore, you can't say that this person did what they're accused of doing or what have you. So think about Wang being arrested. Suppose passing by her, she was near the scene, and then there's another eyewitness that reports it and reports someone that looks like Wang. The officer gets it after looking for the original description of one of the people that did this, that robbed a bank or whatever. Then it makes sense to go back. It's not reckless anymore. Why? It's supported by other facts or information. Okay. You should read chapter 17. It's about persuasive writing style, and it's really important. There's going to be no writing in this class, but it's important to understand, how you go about piecing together a persuasive argument so that your advocacy is as strong as it possibly can be. So you're going to read it, but I'm going to give you the heads up on a few things that they touch on in greater depth about the adversarial approach and the language you should use in order to do that, to communicate effectively. There are certain things that weaken your argument. Cliches, they don't work. Things like, it is abundantly clear that. It's insulting, and it's a fine line between making your point and, insulting the court, right? So just keep that in mind. Cliches don't win the day. Personal attacks do not win the day, right? Avoid them. Remember, you're building an argument. You're not. It's not political in nature. You're not attacking someone because politically they disagree with you or what have you. Sentence structure is important, really important. Where you place the most helpful information. You don't want to bury it, but sometimes you may have to establish, what that is, and then you have to go from there. Just keep as a general rule, it makes sense to take a clause, if you're going to go ahead and you're going to sort of explain something and pop it into the middle of your brief. The impact of the facts are important. how facts get interpreted and applied is really up to the court, right? Whether you've made your argument that those facts should or should not be applied. So keep in mind that there is, it's key how to write that. You should read that. Now the oral argument before the court. We're talking about, appeal and, pretrial or trial motions. Obviously, you're going to argue the case orally. That's why it's an oral argument. You're going to submit all all the written briefs. The court's already seen those. And hopefully your brief, if effectively written as we've talked about, will influence the judge that basically your oral argument is making or will make more sense, right? That it is you read the brief, it looks very strong. The oral arguments then support that. If it's a strong brief, the court is likely to take the oral argument, which is consistent, hopefully, and make it at least interpreted as being more on spot, right? All right, so there's a pattern to oral arguments. It's not just talking, right? And it's similar to that of filing a brief. That's why the briefs, if well structured, the oral argument should be structured consistently as that brief, and it just drives home, the point you wish to make. All right, so the first part of the general format here is the opposing advocate responds, and the first advocate has the opportunity for rebuttal, right? Oral argument follows the pattern. The advocate seeking relief or the reversal of a judgment in the lower court argues first, which always makes sense, right? Here's my argument. We're the ones bringing the case, and here's our argument. Then the opposing advocate responds to that argument. Now, finally, the first advocate comes back in and has an opportunity to rebut to make it simple, what the defense has said. Now, the rebuttal is really important. Think about it. The person or lawyer bringing the case has the last shot. Okay, there's no rebuttal to the rebuttal, right? So it's really something very important and powerful. Think about it. The person who opens the oral argument, right, which is the advocate for, say, the plaintiff, has an opportunity to respond directly to the oral argument of their opponent. Gets to say, here's what's wrong with what they just said, right? If you will. If you give the opening oral argument, you should always preserve the opportunity for rebuttal. You have to ask for that, right? So it's very powerful, and it should be used, obviously. All right, formality and demeanor in the court. Look, you have to be very respectful. It's a serious process with serious outcomes, and you can't just, walk in willy-nilly. I know that there are, in popular culture, we like to talk about lawyers that do that. You would never do that. You would never sort of just come in and not have prepared arguments, or even the way you look or the way you carry yourself, right? You don't want to sit down and, deliver your arguments, right? Opposing counsel listens, right? But keep in mind that you have to respect the court. You have to respect the court. All right. There's greater formality on appeal, and they expect that. They expect that the oral arguments will happen before a lectern, and you'll get up and you'll make those arguments, then you'll take your seat. Okay, so it's formal in oral arguments. It's okay to be relaxed and confident. You should be those things. But it's not okay to be in some way argumentative. You can make your point, right, and the like, but without being argumentative. Sounds strange, right? And insulting. So what's the content of the argument, the oral argument that you should be making? The first is introduction. So in a formal courtroom argument, you should begin by presentation by introducing yourself in your representative capacity. Pretty straightforward. If you don't know that, there's already a lot of trouble, right? You know who you are, and you begin. You're most familiar with hearing things like, may it please the court. That's the beginning of. Now, you don't have to necessarily do that. It's been done so much that sometimes people feel, lawyers and courts, that that's a bit much. And so Yeah, but that's up to you. Traditional salutations, if you depart from them, you know, hopefully the judge is in a receptive mood. Again, it's the judge's court. It's the judge's court. They control that court. All right. So the general strategy here is that the courts impose a time limit on each oral argument, because that's what we're talking about here. You know, some courts may allow as long as 60 minutes for each side, but basically it's 15 to 20 minutes is what's more, typical. How long it will be is a function of the court you're in and the case before the court and what that court's process is. Okay, so using the facts, many judges will advise all advocates before argument that the judges are familiar with the facts of the case and that the advocates should proceed with their legal analysis. Important. We've read your brief and we've seen the arguments, but we've read your brief. Now we want to go at your arguments, right? We know the facts. You know, those aren't in dispute. But now the way in which they've been analyzed and applied, that's what we want to talk about. So you ordinarily should not begin your argument with a lengthy recitation of the facts beyond a general characterization of the nature of those facts. You don't repeat all the facts, but the nature of those facts, you know, what those facts speak to, and the like is fine. Remember, if you're going to use facts, make sure you're clear about the sources of those facts. All right, one of the things that in appellate court happen automatically or should happen is, you know, the judges are familiar already. They've read, you know, as I said, the briefs. They're up to speed on that. They've read all that needs to be read, and they want to get to the arguments. And so right away they start interrupting, you know, because they have questions already about the analysis. And some judges, as I've said before, may favor one side or the other, and their questions are to lead that side to make the most important and valid arguments, whether they've made them in the brief or not. Those justices that are trying to, you know, take the argument and, you know, pull it apart will do just the opposite. They'll challenge and look to show weaknesses. Now that seems like they're involved in the case, but they're not. What they're trying to do is test your argument, lead you in the right direction for interpretation, or attack your arguments really for the other justices. It's their chance to demonstrate to the other justices, this is why this argument is weak, or this is why the argument makes sense. So it's about swaying the judges. It's judges trying to sway judges. They know what the case is about. They know your analysis, and now they want to get into it, right? All right. So you should think of it as a good thing, not a bad thing. You know, again, the judge's questions can reveal areas that, you know, the judge has got problems with. I like your argument, but I have a problem with this. Now you have an opportunity to address that, right? You know, this means that you're being allowed to influence the way that justices or judge is thinking about that issue. You know, my issue or my problem with this is X. Okay, now that may not have been addressed in my brief at all, probably not. So now I know what's bothering that judge, and so, or the judge has an issue with, and I want to win that judge to my side, right? So now if I address that question that's been asked properly and put in the context of everything else that I presented, it may be persuasive. That judge may say, you know, in their own mind, that resolves my issue. Okay? Now, sometimes a judge will press for you to give them some sort of a concession. You know, get rid of your, you know, you have this weak point here. You know, can you make another argument? Right? Your approach there is weak. Can you make another argument that bolsters your argument? So keep in mind, you know, even though you have to get rid of an argument to make your argument more credible, you know, you should shift to that more productive topic. Okay? So here I'll give you an example of this is on 377. Your Honor, I prefer not to waive our argument that Todd has standing to establish unreasonable use of force based on the totality of the circumstances, including evidence showing how the entire police operation affected all the students. I do concede, however, that unreasonable force is a secondary argument. Our principal argument on appeal is that the police violated the Fourth Amendment by detaining and searching Todd without even reasonable suspicion that any illegal activity was taking place. We're not going to get rid of this argument, but we're going to concede a second point. We're cleaning up our argument. Oral arguments are about persuasion and cleaning up what you've done and shaping it or reshaping it in such a way that you have made a better argument for the court, which helps those judges make a determination about whether or not they're going to support your argument. Make sense? Okay, so how do you do this? You got to be ready with oral arguments to discuss the facts, holdings, and reasoning of any case that you seek to rely on or to distinguish. The facts, the holding, or the reasoning. You've got to be well versed in the case. If you're going to bring up citations and you're going to say that this decision supports our argument, you better know that case inside out. You're going to be questioned on it. The interpretation of it. Is this really how this case was applied? Or what happened here, the facts were applied. And aren't your facts somewhat different because the essential facts here are not consistent because they deviate from the main cause of the arrest or the like. You better be ready to cite the record to identify those, and you better be able to discuss policy implications of alternative holdings. If you hold this way, you're going to violate that policy, the intent of it, or you're expanding the intent of that policy well beyond what the legislative body intended. In examining and coming up with a policy and holding hearings, the legislative body particularly addressed that issue and decided that that issue was not important to their intent in writing that policy. The law is about policy. And if you can get to the policy, that's really critical because it shows that the intent has been accomplished. And if the intent of the policy has been accomplished, effectively, given your facts and given the other things that support how we interpret that policy, your argument gets very strong, right? If you can't do that, if you can't give a satisfactory answer to those questions, well, you've got a problem. All right, you can't always predict, right, the number of questions from the bench. You don't know really what they're going to ask you, but you have to be prepared to do one of the following. Two things. One, present your arguments without interruption until your time elapses, it's over, or you otherwise finish your argument. Or two, present a brief introduction, respond without break to a series of questions that take up all your allotted time. That's what you've got. Get through it all, or, present it briefly and then deal with the questions, and your prepared conclusion, and you're going to eat up your time. All right, and get to the end of it. The conclusion of your oral argument should end your argument on a compelling note. Perhaps with a summary of your strongest points, a carefully planned conclusion will particularly help if a persistent questioning from the bench prevents you from covering all the points that you had planned. Sometimes the questions from the bench don't allow you to get to something that you think is important. And in your conclusion, you should hammer that home. You should bring it up, establish it, and make sure that the most compelling argument is the one you sort of end off with. You want to go after the most important. You want to drive that home, the most important argument you're making. Now, look, unless you've done this a lot, you're going to be nervous. You're going to do some verbal, missteps, and the court understands that. So long as the court can understand the point you're making, they don't care how many times you're clearing your voice or if your voice quivers. So long as you can get, and you can face their questions and respond, effectively, then that's fine. That's all the judges really expect, right? And if you respond to the questions, that's all they care about. So nervousness and, sort of verbal tripping over yourself is expected so long as you're clear, because it's a difficult thing to do, the oral argument. So long as you're clear and the judges can understand it and you've worked your way to where you want to go. So as long as they understand you, you're fine. And so long as you minimize all these unimportant, things in your argument or things that just distract from, the delivery of the argument and the effectiveness of the argument, especially caused by nervousness. It's very normal to be nervous. Now, they offer on page 379 a way to sort of, deal with this. One is to deal with nervousness at the beginning of your argument. You can prepare a carefully worded introduction that you can commit to memory. One way you're less nervous is if you've memorized your introduction, if you know how you're going to start, so that you're not fumbling right from the beginning. Okay? Keep this in mind because this is very important in terms of making and expressing your advocacy. And there's a case that they give you that they've used before on page 380. It's Calzona Superior Court. That's a case worth looking at because it will speak directly to what we're talking about. The next lecture is going to be on the complaint, and then after that we'll talk about the answer. So I'm sorry. The next lecture will be about the answer. We're going to finish up this lecture, in the next half hour or so by looking at the complaint. Okay. All right. The primary tools, right, in the complaint, right, in forming the complaint, you're looking at facts and applicable law, so that hasn't changed. You're looking at rules of procedure and local court rules provide necessary guidance, right? So you're looking at the same things. You're looking at the facts, the applicable law, the rules or procedures, and local court rules. Those things guide your complaint, right? What are the facts, applicable law, the rules of procedure here, and local court rules. You can't really screw that up. If you do, it's problematic. So what about format and content? Federal Rule of Civil Procedure 8A requires a complaint to contain 3 elements. Now look, there are federal rules, right? It makes sense, like federal rules of evidence and so on and so forth. Here's civil procedure. You want to follow those rules. They're consistent. They're across the board, no matter what court you're arguing in, for the most part. And so there are 3 elements. The first is a short and plain statement of the grounds for the court's jurisdiction. You got to say, here's why the case is here in your court. Second, there's a short and plain statement of the claim showing that the pleader is entitled to relief. Hey, we belong here. This is the right court. And my client should get relief, right? Whether it's money or whatever. And the third part that you have to have is a demand for the relief sought, which may include relief in the alternative or different types of relief. There's different types of relief you could get. So basically, hey, we're in the right court. My guy should get what they're asking for. And basically, this is what we're asking for, what we're seeking. The guys are right to it, and this is what we want. Okay, now you've got to sort of expand on all of those things. So the jurisdictional statement is particularly important in a complaint filed in federal court because the subject matter jurisdiction, keep that in mind, subject matter rather than personal matter, subject matter jurisdiction of federal courts is limited to that authorized by Article 3 of the United States Constitution and federal statutes. Okay. There are cases where you can go into federal court, into state court, and that's not what we're going to touch on. Okay, we're going to make this simple and pretty straightforward. So, for federal system, right, especially if it involves the Constitution and federal statutes, not if it does, right, then you have to demonstrate jurisdictional, through a jurisdictional statement. You have to show that this is the court it belongs in. Does it belong there? Not because you say so. Judges make the determination. All right, so in the initial paragraphs of the complaint in federal court, you should allege facts establishing subject matter jurisdiction. This subject gets dealt with on the federal level, not the state level. And therefore, we're in this court because there's a federal issue here that must be addressed. So the subject is federal in nature, as has been outlined in the Constitution, right, or in Article 3 of the United States Constitution, or by federal statute, saying this is where this case is going to go. So in that initial paragraph, you should allege the facts that establish the subject matter jurisdiction, right? That there's a federal, based on a federal question, diversity of citizenship or a special statutory grant of jurisdiction. Those are the three things, right? Constitutionally, it's there, right? Subject matter, it's a federal question. Diversity of citizenship, right? That's one thing. Special statutory grant of jurisdiction from the Congress. All right. So this is key in your jurisdictional statement, in your complaint. When you're going to plead subject matter jurisdiction, it's less important in state court than in federal court, because most state trial courts are courts of general jurisdiction, meaning that they pretty much cover generally everything except those things which belong in federal court, because there's federal, subject matter jurisdiction. So you don't need to kind of say, hey, we're in this court and here's why, because typically the courts in the state, cover all issues, except those, again, with a federal question. Many state rules of civil procedure have adopted all the elements of the governing federal rule of civil procedure, thus requiring some statement of jurisdiction in state court complaints, because that's what they say you should do with federal courts. You don't necessarily need to do it. It's not as important there, I should say. All right, so because a special allegation of subject matter jurisdiction is less clearly necessary in a state court complaint, state pleaders often begin their complaint with allegations of personal jurisdiction over the defendants. Okay? Now we get to the claim for relief. Federal Rule of Civil Procedure 8.2 omits any reference to facts in its requirement of a statement of the claim for relief. Nonetheless, that same rule envisages the statement of circumstances, occurrences, and events in support of the claim presented. You guys set up the groundwork. You're not going to go into that in great detail. So the main body of the complaint, you allege the facts and conclusions of the liability. That's the claim for relief. That's that second part. You got to do that effectively, but you do that by determining three things. One, the extent, if any, to which you should supplement fact allegations with references to law. Two, the specific content of the fact allegations. And three, the appropriate level of specificity of the allegations. Okay, these are important. The extent, if any, to which you should supplement fact allegations, okay, with references to law. You have to think about that, right? Remember, you're putting together a complaint. And by putting together the complaint, what you're trying to do is, in that second part, say you have a claim for relief, right? That this person should get some relief. So you have to look at supplementing any fact allegations with references to the law. That's what you should do there. The specific content of the fact allegations should also be included, and the appropriate level of specificity of the allegations. So basically what you're talking about here are the allegations. This allegation that we're making, right, these facts support it based on the law, right? The content of those fact allegations are this. This is how these facts are defined and so on. And then the appropriate level of specificity of the allegations. How specific do you have to be with these allegations, right? Those are the things you have to sort of adjust. So the first thing, allegations of fact and citations of law. Look, there's a basic syllogism here of deductive reasoning. You deduce. You have that major premise, which is the rule of law. Okay? Then you have the minor premise, which is the allegations of fact. These facts demonstrate this. This is the rule of law. That's what we've got. Now, the minor premise is allegations of fact, and the conclusion takes allegation of liability or other ultimate conclusions. So you say, here's the rule, here's the allegations of fact, and now in this last part, we're going to show the relationship between those two things. Just keep that in mind. There's syllogisms are important. They're important, obviously in deductive reasoning, they're essential, but are important because you're saying, hey, here, this is the rule. Here are the allegations of what the facts are, and you can see these facts apply to that rule. You see how that is pretty tight reasoning, okay, if you're successful at it. So the substance of allegations are pretty much the same as what we expect, news reporting to be. It's the who, what, when, where, why, and how, right? We dropped the how in this case. So who? in some complaints, you'll introduce the parties in the jurisdictional allegations. This belongs here because these parties represent, some element, like a diverse citizenship that makes them belong in federal court. So that's the who, right? Otherwise, you just basically identify them in relationship to one another, the defendant, the plaintiff, that sort of thing. The what, where, and when is about the claim. And it has to describe the events that give rise to the claim. It's really about the facts. What, where, and when are the facts apply to that, not who. Who is, those that are involved. But the actual facts are the what, where, and when. Think of them that way. Okay? And then you get to the why, which is, you should allege that any state of mind that is material to the claim or to the availability of special relief. In other words, why should you get this? Why? Demonstrate why this relief should be granted. So in the first, it's who is here, and that's naturally tied to the jurisdictional issues, right? Because if they're not the right parties, if they're parties in the wrong court that doesn't have jurisdiction, you've got a problem. You don't move beyond that. Then the what, where, and when gives you all the particular facts that you need then to apply to the rule or have the rule apply to then get to the why the relief should be granted. If you can't do that effectively, then you're not going to be able to win the day. So there's a good example. It's on page 390. For example, suppose that the jurisdiction in which the complaint is filed recognizes a cause of action for intentional infliction of emotional distress on proof of 4 elements. Now, the elements of a policy or of the law have to be satisfied either in toto, all the elements, like the particulars of it, or sometimes it's just a number of those elements have to be present in order for you to demonstrate that this particular situation satisfies, the facts satisfy what's required by law, to make a claim for intentional infliction of emotional distress in this particular case. The first is the defendant engaged in extreme and outrageous conduct. Okay. If it was not extreme and outrageous conduct, then you haven't satisfied that one element, right? And what you've got is if you have to satisfy all 4, right? And you do in this case, right there, your argument falls apart. Let me read the entire statute and then show you how the pieces break down. So the defendant engaged in extreme and outrageous conduct with the intent to cause severe emotional distress or with reckless disregard for the possibility of those consequences, and the conduct caused the plaintiff to suffer severe emotional distress. Fourth. Okay. Engaged in extreme outrageous conduct, intent to cause emotional distress with reckless regard, right? That could happen. The conduct caused the plaintiff to suffer. So what? There's a causal relationship. Probable cause, right? Severe emotional distress occurred. They suffered it. Any one of those elements are gone, you don't have an argument for an intentional infliction of emotional distress. You got to prove those 4 elements. So what might those look like? The defendant engaged in extreme and outrageous conduct. What do we mean by extreme, and outrageous conduct? Now, again, it's words, so the interpretation is going to be different in some ways, right, depending upon the facts. Extreme and outrageous conduct is what normal people would not do. Think of it that way. A normal person wouldn't drop a cinder block from a 6th floor roof, right? That is of an apartment building. There's someone they don't like walking on the street, and they figure they're going to drop this thing and scare them, right? Not hurt them, but scare them. So that's extreme and outrageous conduct. People don't do that normally. With the intent to cause severe emotional distress with a reckless disregard for the possibility of those consequences. We want to scare this person, right? We want to scare them. We want to, really get them freaked out, cause them distress. And we've not thought about the consequences of that for that person, right? Third is the conduct caused the plaintiff to suffer. In some way, you have to show that you suffered. If you didn't suffer, then what's the issue? What's your complaint? You're fine, right? if every day this person did that as a routine, and you knew about it, would look up and go, oh, and you'd walk on, but every day you took the same route, and your life didn't change at all, this element is probably not there. And so severe emotional distress, what is severe emotional distress? Not only that you're scared, but what would distress a person in such a way that it's difficult to get over it emotionally, right? That cinder block being dropped from a 6-story apartment building with the intent to scare someone, if it was to hurt them or kill them, it's attempted murder, right? So this is just, emotional, the intentional infliction of emotional distress. And intentional means that if the person was walking on the 6th floor and didn't see the cinder block and kicked it, and it went over the building and everything else was there, you would say, well, it wasn't intentional. It's the wrong particular, policy, resolution for this sort of thing. It's not intentional. You didn't mean to do it. And it's for emotional distress, which you didn't mean to do either. Now, was it careless and reckless? Yeah, maybe. You should know, that particular cinder block might have been there. But there's no way to really know, that it was going to have the effect it had when you kicked it. So here's the 4 parts as a infliction of emotional distress. An example. This is the relationship of the parties. You want to establish that. Jensen worked on an assembly line at the Zydeco radio factory under the direct supervision of Boswich, or Boswich, depending upon how you want to pronounce it, I guess. As Jansen's supervisor, Boswich had the authority to impose production quotas on Jansen and to impose discipline, including termination, for failure to meet those quotas. That's the relationship. That's the responsibility of one to the other. And so that's the relationship. Okay, we've established that. Next is the conduct. From April 1st to June 10th, 2010, Boswich engaged in the extreme and outrageous conduct, there it is, of imposing impossible production quotas on Jansen and causing Jansen to believe that his job security depended on his meeting those quotas. Conduct. You better meet these quotas. Although it wasn't said, Jansen believes I'm going to lose my job unless I meet them. The state of mind. Boswich maliciously engaged in this conduct for the purpose of causing Jansen to suffer severe emotional distress. Didn't like him. Wants him to be freaked out. You got to meet your quota. Got to meet your quota. Got to meet your quota. Right? Alternatively, Boswich recklessly disregarded the likelihood that Jansen would suffer such distress. This would freak anybody out. Why did you ignore that fact when you did it? And then the causation and severe distress, which is you've got to show the connection that there was severe and emotional stress, is that on June 10, 2010, as a direct result of Boswich's conduct, Jansen suffered a complete nervous breakdown, required bed rest, and 3 weeks and extensive medical care. All the elements are there. Now, the other side would show that this is not, that there was not sufficient evidence that there was a nervous breakdown. You get doctors in, to describe how there's an uncertainty with these nervous breakdowns and the like. And then finally, Jansen continues to suffer insomnia. It goes on, right? It sort of moves permanently. Headaches, inability to concentrate at work, general nervousness, and other emotional distress as a result of Bosch's conduct. Okay? Now, there are specificity of fact allegations on 391 I'd like you to read, which we won't talk about. And there's notice pleading and the minimum requirements, and this is important. A bare allegation of liability or legal conclusions without any supporting factual context would be insufficient even under the relaxed, quote-unquote, notice pleading standards of the federal rules. Okay, although Rule 8A2 does not require, quote, detailed factual allegations, it does require more than labels and conclusions. A formulaic recitation of the elements of a cause of action, naked assertions devoid of further factual enhancement, that's the definitions of them, or conclusory statements without factual context. So the appropriate level of detail or generality of the factual context can be illustrated by the continuum that represents varying degrees of specificity in fact allegations. The continuum begins with allegations of legal conclusions based on underlying facts. It gains steadily in specificity until specific evidence from which factual inferences can be drawn and which factual conclusions can be based. Okay? That's confusing. go read 391. Here we have it. Legal conclusion. Is an example. It lays it out. Legal conclusion, negligence. Okay. Factual conclusion. Defendant exceeded the speed limit, breaching a duty of care. Now, when we talk about towards negligence, there's a duty of care. Did this person act responsibly? Did they understand the consequences of their actions, and did they adjust those actions so that there would not be a breach? That's the factual specific evidence. Eyewitness estimate of speed and analysis of skid marks. So that's specific enough, right? How fast they were moving, the person broke, did try to brake, but it hurt someone. Did they apply the duty of care? No. Then that means they were negligent. The facts are the person was speeding based on eyewitness accounts and looking at the skid marks the person tried to stop. So here's an example of it. Jill Graham and Ben Cooper were standing at the corner of 7th Avenue and Washington Street in Smallville at noon and observed the defendant driving his automobile west on Washington Street past 7th Avenue and toward 8th Avenue. Each of them observed that the defendant was traveling at a substantially greater speed than all other cars proceeding normally in the same direction, passing them easily. An expert who examined skid marks at the accident scene estimated that the defendant's automobile was traveling at 40 to 50 miles per hour when it entered the intersection at Washington Street and 8th Avenue. Okay? That's all. That's what we lay out, right? We had there the legal conclusion is there was negligence. What factual conclusion has to be based on factual conclusions, which are there's a speed limit and they were exceeding it, and then you have to have specific evidence. Don't have to go on forever with the facts, right? The facts, eyewitnesses, and the like. All right. On 393, there is there's an example of this, which I want to go over. First, I'm going to state the Supreme Court and what they've decided. In 2007 and 2009, the U.S. Supreme Court joined this trend by requiring allegations in federal complaints to state a claim to relief that is plausible on its face. This new plausibility standard, remember that, does not require allegations that establish the probability of liability, nor does it transfer the more rigid particularity requirement, this is Rule 9. On a motion to dismiss under Rule 12, however, the plausibility requirement does direct a federal judge to use experience and common sense to determine whether the factual allegations permit a plausible inference of wrongdoing rather than the mere possibility of wrongdoing. A plausible inference of wrongdoing. Supreme Court, right, requiring allegations in federal complaints to state a claim to relief that is plausible on its face. If it doesn't seem plausible, we're not moving, forward, right? Now, the plausibility standard does not require allegations that establish the probability of a liability, nor does it transfer the more rigid particularity requirement. On a motion to dismiss under Rule 12b6, however, the plausibility requirement does direct a federal judge to use experience and common sense. So it's plausible. You have to show a whole bunch of facts if it's plausible on the face of it to the judge. So this doesn't make any sense. And you need not go any further than that, examining any of the, particulars. So some attorneys will prefer to allege little more than is minimally required by the rules in each case, right? They don't want to prematurely lay out their entire case and commit the plaintiff to those arguments. So they'll generally do it, right? Minimally do it. Some commentators, however, have argued for relatively complete, rather than just, playing it safe, complete and compelling narratives and complaints to advance effective advocacy and earlier stages of litigation. All right, so some say minimalist, right? Let's get only what we need out there at the beginning. We don't want to be too committed to everything. We want some room to move. The other argument is, no, you get your whole thing laid out. You make the strongest argument. You do the job of boxing this thing in as best you can. You don't want to leave it too open. So pleading, if you look at once the pleading rules have been satisfied, any additional specificity in your allegations is partly a matter of style and strategy. You go narrow, fine, but everything else you add, you better have an overall strategy for this, and it has to fit. The more you say, the more likely you are likely to leave doors open. However, the less you say, the more likely you are to not get your point across. This is what experience tells you. We don't want to bring this in because they're going to respond to it that way. We want to leave that out. Or we need to address what they're going to say, cut them off the pass. All right. So the next part, last part, is a request for relief, right? That's the third thing. So you have to end with a simple, statement of, hey, here's what we want. You can't leave that out. The court's going to say, okay, so if all this is provable and we support it, what do you want? You got to say what you want, right? So the main request for relief, obviously, is either an injunction or an award of money damages or both, right? There's nothing going on here, or we want money damages or both. All right. Additionally, you should request an award of reasonable cost and attorney's fees if your client has a legal basis for such an award. Look, if you have a right, you want to be reimbursed. If someone is taking you to court, believing that they can run up your legal costs and that's going to make you not want to go to court, or if this is the process that the judges use, they're going to go ahead and do it. So going back to Jansen, therefore, requested judgment granting the following relief: an award of compensatory damages in the amount to be set at trial to compensate the person for it, an award of punitive damages to punish person that did this, because they might likely do it again, and start harassing somebody else at work, in an amount to set a trial, an award of reasonable cost and attorney's fees, and other relief as the court deems appropriate. You always end it with that. Hey, if I've missed something, you guys can give me some more if you want on whatever. All right, so that's very important, right? Remember that the organization, we're not going to get to the answer yet. That's next time. The organization is important. The writing is important. As I've said before, my assumption is that you've read already, right? You've read what needs to be read. And I've gone over it, reading different parts of it that you've already read, but directed you to those pages. And then I've annotated and expanded on the ideas. If you're listening to the lectures before you do that, I suggest you read and go back and listen to the lecture again, only because it'll be clear. And so when I talk about what's going to be on the midterm and how that's going to get approached, you need to know those things, and then you can talk about your level of comfortability around them and what you need to go back and really look at. It is easy, as a lecture moves forward, to timestamp where I discuss something and what page I'm on, so you can go back and look at it. If I am saying something in lecture, you have to assume it is likely you'll see it on the midterm. So knowing those things and being able to mark them is going to be greatly helpful. On the midterm, don't forget also it's an open note, open book, test. So you're given a certain amount of time to do it, but if you focus on how you place those things, the test should be pretty straightforward for you. The idea is that you're learning the legal process, and I mean this is in depth. It's not. We're not taking a political approach. We're taking a practical legal approach to how cases move through courts, and what that process looks like. So we've gone over things like advocacy and a complaint now and the answer next time. So there's a process here. All right, that ends lecture 4 up to the answer, which we're going to go to next time. All right, so that completes this lecture for legal process.